The judge was sure that this process was a mere formality and that Barron Trump was not a threat. But as soon as he spoke, the whole room froze. Subscribe so you don't miss new stuff, and post in the comments where you're watching from. The heavy oak desk in Barron Trump's study was lined with neatly arranged books on law, philosophy, and political theory. The dim glow from his desk lamp cast soft shadows over the pages of a legal case he was studying. Unlike the public's perception of him, he had little interest in fame or the glamorous circles his family name could grant him access to. Instead, he preferred quiet solitude, poring over complex legal doctrines, tracing the evolution of judicial philosophy, and dissecting arguments of the most brilliant minds in history. His passion for law wasn't something he openly advertised. Most assumed he would either fade into obscurity or emerge as yet another public figure living off the reputation of his lineage. Few knew the depth of his analytical mind, the patience with which he deconstructed arguments, or the almost ruthless precision with which he identified weak spots in legal reasoning. He did not seek validation. His measure of success was found in understanding, in seeing through the layers of rhetoric and power games that often masked the raw machinery of justice. On this particular evening, he was not reading for pleasure. A message from an old friend had disrupted his usual routine. The friend, Ethan Carter, had been a promising software engineer working for a leading tech company before being unceremoniously fired and subsequently sued. The corporation accused him of violating a non-disclosure agreement, alleging that he had leaked proprietary information to a rival company. The lawsuit demanded an astronomical sum in damages, effectively ensuring that Ethan would never work in the industry again. Ethan had reached out to Barron in desperation, not because he expected a miracle, but because he had exhausted every other option. No firm would take his case, fearing retaliation from the powerful company. His former employer had deep pockets and an army of top-tier attorneys. Fighting back seemed futile. Ethan wasn't naive. He knew the legal system often tilted in favor of the powerful, but he also knew that Barron was different. Barron had listened patiently as Ethan explained his predicament, the hopelessness in his voice barely masked by forced composure. When the call ended, Barron sat in silence, his mind already racing through the possibilities. It was a textbook case of corporate overreach, a classic example of a company using its legal might to silence a former employee. What intrigued him was not just the injustice of it, but the glaring weaknesses in the case itself. He requested Ethan send over every document related to the case, his employment contract, the NDA, the lawsuit, any communications with his former employer. Hours later, his inbox was filled with attachments. Barron combed through them meticulously, highlighting inconsistencies, making notes in the margins of printed copies. The more he read, the clearer it became. The company's case was built on shaky ground. The non-disclosure agreement had been poorly drafted, with vague language that left room for multiple interpretations. The company's evidence was circumstantial at best, and some of it appeared to have been obtained through questionable means. Most importantly, the contract itself had provisions that the company seemed to have ignored, provisions that could dismantle their entire argument if presented correctly. The next morning, Ethan called again, his voice edged with anxiety. He didn't ask if Barron had found anything useful. He assumed that even if he had, it wouldn't make a difference against a corporation with unlimited resources. But Barron's response was calm and decisive. "We're going to fight this." Ethan hesitated before replying. "We? I'll represent you. A stunned silence followed. "Barron, you don't even practice law." "I don't need to. I just need to know it better than they do." Ethan wasn't convinced at first, but the more they talked, the more he realized that Barron was serious. More than that, he was prepared. He had already outlined a strategy, identified key precedents that supported their position, and anticipated the opposing counsel's likely arguments. News of Barron taking on the case spread quickly. The media seized on the story, the youngest son of a former president stepping into the legal arena without a law degree, going up against one of the most formidable corporate litigation teams in the country. Pundits dismissed it as a stunt, speculating that he would be crushed by the opposing counsel. Social media was divided. Some saw it as arrogance, others as a bold act of defiance against a corrupt system. In legal circles, the reaction was more measured. Some lawyers scoffed, calling it reckless. Others, those who had quietly followed Barron's intellectual pursuits, were more intrigued than dismissive. They knew of his sharp mind, his relentless curiosity, his ability to see patterns others missed. If nothing else, they were interested to see how he would handle himself. The judge assigned to the case, Franklin Barlow, was known for his stern demeanor and traditionalist views. He had little patience for theatrics, and even less for amateurs in his courtroom. He had presided over countless cases involving corporate law and was widely respected for his legal acumen. However, he was also infamous for his skepticism towards young lawyers and his disdain for those he perceived as privileged upstarts. The opposing counsel, Richard Marlowe, was a courtroom veteran. He thrived on intimidation, known for the way he dismantled witnesses and opposing arguments with a mix of sharp logic and psychological pressure. He had never lost a high-profile corporate case. To him, this was just another routine victory. The fact that his opponent was Barron Trump only made it more amusing. He anticipated an easy win, perhaps a little extra media attention, but nothing more. Barron, however, was not concerned with the public perception. He was focused solely on the law, on the facts, on the logic that would guide his approach. He did not seek to impress. He sought only to win. On the day of the first hearing, the courtroom was packed. Journalists lined the benches, legal analysts whispered among themselves, and students from nearby law schools had come to witness what many expected to be a public humiliation. Marlowe entered with the confidence of a man who had already won. Judge Barlow took his seat, his expression unreadable as he glanced at the young man seated at the defense table. Barron sat quietly, flipping through his notes with steady hands, his expression devoid of nervousness or excitement. He was not here to entertain. He was here to prove, with cold precision, that the law was on his side. As the bailiff called the court to order, all eyes were on him. And in that moment, Barron Trump was exactly where he wanted to be. The courtroom buzzed with anticipation. The air was thick with the quiet murmurs of journalists whispering to one another, legal interns jotting notes in their pads, and courtroom regulars waiting to see how this unusual case would unfold. Barron Trump sat at the defense table, composed and still, his fingers lightly resting on the neatly stacked documents before him. His expression gave away nothing, not the pressure of the cameras pointed in his direction, not the weight of the expectations both for and against him. He was an anomaly in this room, an untested force stepping onto a battlefield where the rules were written by those who had spent decades mastering them. Judge Franklin Barlow settled into his chair, adjusting his glasses as he scanned the docket. His eyes flickered toward Barron for the briefest moment before returning to the documents before him. His expression was neutral, but there was an undeniable undercurrent of skepticism. Everyone in the room knew his reputation. He had little tolerance for arrogance, even less for inexperience, and absolutely none for what he considered spectacle. In his mind, this case had already veered dangerously close to that last category. Richard Marlowe, the plaintiff's lead attorney, exuded an air of effortless confidence as he stood to deliver his opening statement. His reputation preceded him. He was a master of the courtroom, a man who turned cross-examinations into dissection tables, his words as precise as a surgeon's scalpel. He began smoothly, his tone controlled, his pacing deliberate. "Your Honor, ladies and gentlemen of the court," he started, casting a glance toward the gallery where journalists eagerly scribbled down his words. "What we have here is not a complicated case. It is, in fact, a very simple one. A contract was signed, a clause was violated, consequences must follow." His voice carried a practiced authority, the kind that could make even the most dubious arguments sound irrefutable. He detailed the accusations against Ethan Carter, painting him as an employee who had knowingly betrayed his former company by disclosing proprietary information to a competitor. He spoke of trust, of corporate responsibility, of the fundamental need to protect intellectual property in a fiercely competitive industry. Marlowe's words flowed effortlessly, each sentence meticulously crafted to build an image of inevitability. He threw a glance in Barron's direction, a flicker of amusement crossing his features. To him, this was routine. The fact that his opponent was someone so young, so inexperienced, was an inconvenience at best, a source of entertainment at worst. He had been in courtrooms for decades, refining his strategy, dismantling opposition with ease. This would be no different. As he concluded his statement, he stepped back with the same self-assuredness he had walked in with. Then, slowly, the courtroom's attention shifted. Judge Barlow turned toward the defense table. "Counselor Trump," he said, his tone even but laced with subtle amusement. "Your response." A faint murmur rippled through the gallery. The moment had arrived, the first true test of whether Barron Trump was anything more than a last-minute replacement for a real lawyer. Barron rose. Unlike Marlowe, he did not clear his throat, did not adjust his tie, did not stall with unnecessary movements. He simply stood, his posture impeccable, his expression unreadable. He let the silence hang for a moment, not for dramatic effect, but because he understood the weight of first impressions. Then he spoke. "Your Honor, opposing counsel has presented a compelling narrative." His voice was steady, his articulation sharp, deliberate. "Unfortunately, it is not supported by either the facts or the law." The shift in the room was immediate. Marlowe's smirk tightened ever so slightly. Judge Barlow tilted his head, as if only now considering the possibility that the young man before him might actually have something worth listening to. Barron did not raise his voice, did not appeal to emotion. He moved with precision, outlining the fundamental flaws in the plaintiff's case. He began with the contract itself, drawing attention to the ambiguous language within the NDA, the vague definitions that left ample room for multiple interpretations. He then proceeded to dissect the evidence, or rather the lack thereof. The plaintiff's accusations, he explained, rested on assumptions rather than concrete proof. The so-called proprietary information Ethan was accused of leaking was publicly available through independent research databases, something he had meticulously documented in the days leading up to the trial. More critically, the company's method of collecting evidence was legally questionable, bordering on procedural misconduct. The silence in the courtroom grew heavier. Judge Barlow exhaled through his nose, tapping his gavel lightly against the bench as if contemplating whether to humor Barron or dismiss him outright. The skepticism remained, but it was now tempered with something else, reluctant curiosity. "That's quite the opening remark, Counselor Trump," he said. "I assume you have something more than confidence to back it up?" A quiet chuckle rippled through the gallery, but Barron remained unaffected. He met the judge's gaze with calm precision. "Confidence alone does not win cases, Your Honor," he replied smoothly. "Facts do." Marlowe shifted in his seat, suppressing a sigh. This wasn't what he had expected. He had assumed Barron would crumble under pressure, that he would fumble his way through legal jargon and lose the courtroom before he had even begun. Instead, he had delivered an argument that was not just competent. It was strategic. The judge leaned back slightly, still unreadable, still skeptical, but no longer outright dismissive. Marlowe regained his composure, offering a quiet scoff. "The defense is leaning on technicalities," he said, as if brushing off a minor inconvenience. "But the essence of this case is about trust. The plaintiff placed trust in Mr. Carter, and that trust was broken." Barron turned slightly toward him, his expression unwavering. "Trust is not an abstract concept in contract law, Mr. Marlowe. It is a defined, documented obligation, and when the contract itself is flawed, your foundation of trust collapses under scrutiny." The response landed with weight. A few heads in the gallery turned. Even the court reporter, who had remained expressionless through countless cases, seemed to pause for a fraction of a second before resuming her transcription. Judge Barlow studied Barron for a long moment. "Well," he said finally, his tone neutral, "since you seem so determined to turn this into a law lecture, by all means, educate us." His words were laced with sarcasm, meant to belittle, but Barron did not see it as an insult. He saw it as an invitation. He turned the page of his notes, knowing that what came next would shift the entire momentum of the case. The weight of the judge's words settled over the courtroom. Barron Trump remained motionless, his fingertips resting lightly on the edge of his notes, his expression unchanged. He had anticipated this. He had known from the start that Judge Barlow would not grant him the courtesy of an open mind. He had expected the skepticism, the subtle attempts to undermine his credibility, the implied suggestion that he was nothing more than an imposter in a room full of professionals. That was fine, because while they underestimated him, he had been preparing. He lifted the first document from his stack with a deliberate calmness, the subtle rustle of paper the only sound in the otherwise silent courtroom. His voice, when he spoke, carried the same measured certainty as before, but now there was something else, an unmistakable shift in control. "Your Honor, let's examine Colton v. Redbridge, a case that directly contradicts opposing counsel's claim that the termination in question was lawful." Marlowe barely concealed his amusement. "That case doesn't apply here," he interjected smoothly. "The circumstances are entirely different." Barron turned his head slightly, finally meeting his opponent's gaze for the first time since the proceedings began. His stare was unshaken, devoid of frustration or arrogance. "That's incorrect," he said evenly. "The precedent is directly relevant because the ruling hinged on a key factor, the presence of a contractual clause limiting termination discretion, which in this case also exists." Marlowe blinked, caught off guard for the briefest of moments. The judge's fingers, which had been idly tapping against the bench, stilled. "Miss Leavitt," Judge Barlow said, his tone laced with the remnants of condescension, "I appreciate the effort, But do you really think a single precedent overrides the fundamental principles of at-will employment? There it was. The setup. The moment where the judge, a man accustomed to shaping the trajectory of cases through sheer authority, expected to school him. Barron did not flinch. He flipped through his binder, pulling out another document and holding it up. "Not a single precedent, Your Honor," he said, his voice unwavering. 5, each of them reinforcing the same principle. Employment contracts with clearly defined limitations cannot be dismissed under the at-will doctrine. Silence. The courtroom, which had been a slow hum of murmurs and quiet scoffs, was now utterly still. Marlowe's smirk had begun to strain, though he kept his posture composed. The judge adjusted his glasses, exhaling slowly. "Well, Mr. Trump," he said, folding his hands together, "since you're so determined to turn this into a lecture, by all means, educate us." Barron took the invitation at face value. He turned the next page of his notes, his tone remaining even, unaffected. Preston v. Briarwood Technologies, 2014. The court ruled that despite an at-will clause, explicit contractual provisions on termination procedures took precedence. That case was presided over by Judge Holden, who, as you may recall, Your Honor, cited your own opinion in a similar ruling the following year. The shift in the room was almost imperceptible, but undeniable. The judge stopped tapping his fingers. His expression remained neutral, but Barron caught the slight narrowing of his eyes, a flicker of awareness that he wasn't just quoting any case. He was quoting a case that directly referenced Barlow's own judicial philosophy. A few heads in the gallery turned. Legal interns exchanged glances. Even the court reporter, who had seen enough cases to remain unimpressed by most, seemed to slow her typing just slightly. Marlowe cleared his throat, his voice regaining its usual confidence. "That's still not comparable," he insisted. "That case involved a severance agreement that wasn't honored, which is entirely different from what we're dealing with here." Barron didn't look at him. He simply reached for the next file. Wells v. Dartmouth Holdings, 2017. No severance agreement, just a termination clause requiring reasonable cause. The employer argued at-will discretion, but the court ruled that contractual obligations supersede at-will doctrine. That case was cited in Burton v. Vance Corp., 2019, where the decision reinforced that at-will is not an absolute shield when clear contractual obligations exist. A hush settled over the room. Judge Barlow leaned forward slightly, resting his elbow on the bench. He was no longer laughing. He was considering. Marlowe shifted in his seat. He had prepared for a routine argument, one where he could recite the usual legal rhetoric, get a few approving nods from the judge, and walk away with an easy win. But Barron wasn't playing along. The judge exhaled, rubbing his chin. "All right, Mr. Trump," he said slowly. "That's an impressive list of citations. But let's be honest here. Case law can be interpreted in multiple ways. Are you really suggesting that all of these cases eliminate the right of an employer to terminate an employee under at-will doctrine?" Barron did not hesitate. "No, Your Honor. I'm not arguing that at-will employment is void. I'm arguing that at-will does not override contractual specificity. If a contract explicitly limits termination conditions, then at-will doctrine doesn't apply unless the language allows for it." He turned toward Marlowe now, his posture unchanged, his tone just as measured. "And in this case, the contract states termination must be based on the substantiated cause with supporting documentation. Do you have that documentation?" The silence that followed was deafening. Marlowe's mouth opened, then closed. His fingers tightened around his notes. But Barron already knew the answer before he even spoke. He didn't have it, because it didn't exist. Judge Barlow studied Barron for a long moment. The patronizing tone was gone. The courtroom's energy had shifted entirely, and for the first time it was clear that Barron wasn't just holding his own. He was winning. Marlowe adjusted his tie, scanning his notes as if the answer would suddenly appear. It wouldn't. Judge Barlow exhaled, rubbing his temple. "Mr. Marlowe," he said finally, his voice measured, "Counselor Trump has presented a strong argument. Do you have documented evidence to prove the termination met the contractual standard?" Marlowe hesitated just a beat too long. "Your Honor," he began, his tone still carrying remnants of the confidence he had walked in with. "At-will employment is the foundation of employer rights. It exists precisely to prevent disputes like this from clogging the courts." Barron didn't wait for the judge to respond. He turned slightly toward the gallery, addressing the room as much as the bench. "That's an oversimplification. At-will employment is a default rule, not an absolute one. The moment an employer adds specific limitations to a contract, they've voluntarily given up blanket at-will discretion. They can't use it when it's convenient and ignore it when it isn't." Judge Barlow tapped his fingers against the bench. "So, you're saying the company essentially wrote itself into a box?" Barron nodded. "Precisely. They wrote the rules, and now they're trying to pretend those rules don't apply." The murmurs in the gallery grew louder. Marlowe's frustration was becoming visible. The mood had shifted so completely that even he could feel it now. He wasn't just losing. He was unraveling. Judge Barlow let the silence stretch before he finally spoke. "Mr. Trump is right." The words landed like a gavel strike. Marlowe inhaled sharply, about to object, but the judge held up a hand. This court cannot ignore the plain language of the contract. It was over, and Barron knew it. The weight of the judge's words settled over the room like a slow-moving tide, drowning out any lingering disbelief. For a long moment, no one spoke. The sound of pens scratching against notepads had stopped. The quiet hum of the courtroom, once filled with skeptical murmurs and under-the-breath scoffs, had dissipated entirely. Every set of eyes had shifted, away from Marlowe, away from the judge, and landed squarely on Barron Trump. Marlowe's jaw tightened. The air of smug certainty he had carried into this courtroom had thinned, replaced with something dangerously close to frustration. He knew the case had slipped through his fingers. He had underestimated his opponent, and now, standing here with his notes scattered across the table, he was left scrambling for an escape route. Judge Barlow exhaled slowly, pressing his fingers together as he regarded Marlowe with something between patience and finality. "Mr. Marlowe," he said, his tone no longer carrying the subtle amusement it once had, "your client included a termination clause requiring documented cause. The defense has presented multiple precedents supporting their claim. Do you have any evidence to contradict that?" Marlowe hesitated for a fraction of a second, just long enough for the silence to become damning. Then, with the practiced composure of a man used to navigating losses, he straightened his tie and spoke with forced confidence. "Your Honor, I believe we're getting lost in legal technicalities. At its core, this case is about employer discretion. If we start punishing businesses for exercising their right to manage their workforce, we set a dangerous precedent." Judge Barlow raised an eyebrow, unimpressed. "Punishing businesses? That's quite a stretch, counsel." Marlowe pressed forward, clearly hoping to salvage what little ground he had left. This is about practicality. Employers can't be expected to document every single personnel decision in exhaustive detail. Barron, who had remained composed throughout, finally turned fully toward him. When he spoke, his voice was calm, his delivery surgical. Except when they specifically agree to do so in a signed contract. Another murmur rippled through the gallery. Even the most seasoned lawyers in the room recognized the precision of Barron's counterpoint. He wasn't arguing on emotion. He wasn't grandstanding. He was simply stating a fact that was undeniable. Judge Barlow nodded slowly, tapping his fingers against the bench. His silence stretched long enough for Marlowe to shift uncomfortably. Then, finally, he spoke. "Mr. Trump is right." The words landed like a gavel strike. Marlowe inhaled sharply, as if about to object, but the judge held up a hand. This court cannot ignore the plain language of the contract. The employer voluntarily limited their own discretion. The fact that they failed to meet their own contractual requirements is not a technicality. It's a breach. Marlowe's lips pressed into a thin line. He could file motions, request delays, attempt to maneuver around the inevitable, but the ruling was clear. Judge Barlow sighed and straightened his robe. Given the failure to meet contractual termination conditions, the court finds in favor of the defense. The plaintiff's claim for wrongful termination is dismissed, and the employer is liable for breach of contract. We'll reconvene to determine appropriate compensation. The gavel struck. The case was over. The reaction in the gallery was immediate, a mix of stunned whispers, exchanged glances, and a few impressed nods from the more experienced attorneys present. Marlowe's shoulders sagged as he gathered his papers, avoiding eye contact with Barron as he shuffled away. He had underestimated him. They all had. Barron, meanwhile, remained composed. He methodically closed his binder, placing each document back in its designated folder with the same precision he had maintained throughout the trial. There was no satisfaction in his expression, no smugness, no sign that he had ever doubted this outcome. Winning wasn't about celebration. It was about control. And he had controlled every step of this case. As he stood, collecting his files, he felt a presence lingering nearby. He looked up to find Judge Barlow still at the bench, watching him with an unreadable expression. For a long moment, neither spoke. Then, finally, the judge leaned slightly forward, lowering his voice so that only Barron could hear. "You'll do well in this profession," he said, his tone no longer condescending but contemplative. "Just try not to make too many old judges feel stupid along the way." A few quiet chuckles rippled through the remaining audience. Even Barron allowed himself a small, almost imperceptible smile. "I'll do my best, Your Honor." He turned, walking out of the courtroom with the same steady confidence he had walked in with, except now everyone knew exactly who he was. The courthouse lobby was still bustling when he stepped outside. A crisp afternoon breeze met him as he descended the marble steps, his mind already shifting to the next phase of the case. Behind him, whispers continued. He could hear them, law clerks exchanging quiet remarks, junior associates glancing in his direction with newfound interest. A few law students who had come expecting a spectacle now watched him with something much closer to admiration. He reached the sidewalk and took a slow, deliberate breath. The tension that had wrapped around him for the last several hours hadn't quite dissipated, but the weight of what had just happened was settling in. He had won, not just the case, but something far more significant. Respect. His phone buzzed in his pocket. He pulled it out, glancing at the screen. A message from Ethan. "Case dismissed. Employer is liable. Will call with details. 3 dots appeared. Then, "You're incredible. Thank you." Barron pocketed his phone, his expression unreadable. He had expected to win, had known from the start that the law was on his side, but the outcome wasn't what mattered most. What mattered was that the next time he walked into a courtroom, no one would dare underestimate Barron Trump again. If you enjoyed this, make sure to subscribe for more. Check out other videos for more insights, and don't forget to share this one with others.